Hello everyone, this is Crypto BitLaw, here with another blockchain legal brief, and today we're going to discuss one of the first of its kind DAO governance lawsuits, wherein the plaintiffs to this suit allege negligence and illegality on behalf of the DAO. But before we dive in, please, if you enjoy this content, give it a like and hit the thumbs up button and consider subscribing to our channel. We'd really appreciate that. So with that said, let's jump right on in. Alright, so as we can see here, Blockworks reports that Hack DAO faces lawsuit as users try to recoup stolen funds. A law firm claims all parties involved in a DAO's governance are liable for the protocol's alleged negligence and illegality. They say an estimated $55 million of crypto was stolen after a bZeroX developer had his wallet's private keys taken in a November phishing attack. The 14 plaintiffs' combined losses from the hack total $1.6 million. The victims of a hack of DeFi platform bZeroX are vying for the return of their funds in a rare attempt to hold a DAO liable in court. The lawsuit filed in the Southern District of California Monday names 14 plaintiffs who claim to have lost funds ranging from $800 to $450,000. Together, the complaint indicates the plaintiffs lost roughly $1.6 million from the November hack, during which an estimated $55 million of crypto was stolen. Plaintiffs allege the theft was possible only because the protocol had not yet implemented security measures that its operators knew were reasonably necessary to protect funds. A spokesperson for bZeroX did not immediately return a request for comment. Law firm Gerstein Harrow, LLP, whose attorneys have developed a crypto consumer protection practice, represents the plaintiffs. Its first case, which alleges that a DeFi decentralized finance operator called PoolTogether is operating an illegal lottery in New York, also deals with the issue of who can be held liable for violations of DAOs. DAOs, or decentralized autonomous organizations, are member-owned communities without centralized leadership. The term DAO went mainstream last year when a group of crypto natives, dubbed Constitution DAO, raised $49 million in an unsuccessful bid to buy a copy of the U.S. Constitution. Hedge fund billionaire Ken Griffin won the auction. Quote, "Those who form DAOs apparently believe that they can use the word decentralized to evade corporate and individual responsibility," Gerstein Harrow LLP partner Jason Harrow said in a statement. The opposite is true. Without the protection of a corporation or limited liability company, everyone involved in a DAO's governance is liable for the protocol's negligence and illegality. Defendants include bZeroX protocol co-founders Kyle Kistner and Tom Bean, bZeroX investors Hashed International and AGE Crypto, and bZeroX, which created the protocol and controlled it until August 2021, according to the complaint. It also names bZx DAO, Ookie DAO and LeverageBox, a company that operated the Fulcrum trading platform, as defendants. The complaint argues that because the bZeroX protocol purports to be a DAO that lacks any legal formalities or recognition, it can be considered a general partnership, which is another type of business entity for those that are unfamiliar. Quote, "That means each of the partners is jointly and severally liable for the plaintiffs and must make good on the full amount of its debts," the document states. A bZeroX developer had his personal wallet's private keys taken in the phishing attack, which granted the hacker access to the private keys to the Binance Smart Chain and Polygon deployment of bZeroX protocol, according to a November blog post. The DeFi protocol said at the time the attack was likely executed by Lazarus Group, which is known to be a state-sponsored hacking organization with links to North Korea. The hacker converted a large amount of stolen assets into Ether and transmitted the funds through Tornado Cash, according to bZeroX. In addition to stating on its website in December that it was preparing to launch the bZeroX deployments on Binance Smart Chain and Polygon with enhanced security measures, the bZeroX DAO shared details of its compensation plan for victims. The bZeroX DAO committed to fully compensating those who lost bZeroX, which is a token, in the attack with that asset, amounting to about $20 million of bZeroX. It agreed to pay back victims who lost money via other tokens over time by buying back debt tokens each month using 30% of protocol revenue and fees. But the complaint calls the plan woefully inadequate, adding, at the current buyback rate, full repayment will take thousands of years. All right, now before we go on to discuss the case at bar, or the present case that we were talking about, I just wanted to kind of give a recap on this lawsuit that they mentioned about the PoolTogether DeFi app. And I knew it rang a bell because I remember reading this report about how this DeFi protocol was being sued in New York for an unauthorized lottery scheme, and the connections between Senator Elizabeth Warren and the plaintiff in that case. And as we could see here, just to refresh everybody's memory, the title of this article is "A Guy Put $10 in an Ethereum DeFi App, Then Filed a Lawsuit." They say someone is suing a company linked to the DeFi savings application PoolTogether for enabling an unauthorized lottery scheme. And the key takeaways here, without doing a full deep dive into this, is that a DeFi user has filed a lawsuit against PoolTogether Incorporated after depositing $10 in a pool of funds governed by a smart contract. PoolTogether is a no-loss lottery that lets users stake their tokens into savings pools for a chance to win a weekly prize. The outcome of this case could set a precedent towards establishing a regulatory framework in the DeFi space. The plaintiff has argued that PoolTogether occupies a regulatory gray zone, and it goes on to say that the DeFi user with connections to Senator Elizabeth Warren is the one suing one of Ethereum's earliest yield farming protocols. So, as we can see here, is a former technology lead for Warren's 2020 presidential campaign. And we know, if we know anything, it's how pretty much adamantly anti-crypto Senator Warren is, I can't say that I support her philosophy at all. I think that she's woefully uneducated on the space, and I've said it here many times before that for someone that proclaims to be such a proponent of individual sovereignty and anti-big business and big banks, I think it's just such a hypocrisy that she is such an adamant critic of DeFi and of crypto in general, more broadly. So I just wanted to draw that connection before we move on to reactions and analysis of this present DAO lawsuit case. So let's consider, when analyzing this case, the DAO lawsuit case, this quote from one of the lawyers that filed this suit. He stated, "Those who form DAOs apparently believe that they can use the word decentralized to evade corporate and individual responsibility." All right, and so I think that stands at the crux of ultimately what this case is about and a lot of the unresolved novel issues that are presented in this case. Now, see, I've said it before and I'll say it again. I believe that DAOs, they're just another form of what are traditionally known as business or corporate entities in the legal realm. There's different types of business structures, one of them being a limited liability company or an LLC, a sole proprietorship where there's just one individual that's responsible for the business. Going down the line, you have things like general partnerships, limited partnerships, and then probably the business entity with which you get the most legal protection and the most of a corporate veil, so to speak, would be a corporation, where there are executives and officers of the corporation who act on behalf of the shareholders, right? So the shareholders have ownership rights, and then you have these executives and officers that operate on behalf of the corporation. And if you're running a business in the form of a corporation, generally you will have more of a corporate veil, so to speak, and more liability protection for the acts of the business if you are just a shareholder of that business, right? And so enter in DAOs, or decentralized autonomous organization. Now, I think it's very few. I can only really think of one state in particular that has their legislature actually recognized DAOs in their body of law and has put forth a regulatory framework and structure, laws that particularly deal with DAOs and set up the framework of how a DAO operates. Now, I know that based on a cursory review of the way that Wyoming set up their DAOs is that you could have an algorithmically managed DAO or a member managed DAO. And a lot of it has to go and deal with how the DAO operates in terms of its day-to-day operations and just its general overall structure. If you have an algorithmically managed DAO, most of the functions that would traditionally be taken or undertaken by members and managers would function by way of a smart contract or an algorithm, right? And under the member managed structure, it's the exact opposite. Those types of functions, decisions related to how the DAO operates, are handled by the members. And so here we have this situation where, to my knowledge, California, the state, has not yet set up a statutory framework pertaining to DAOs, legally recognizing DAOs. And so I foresee in that instance, much kind of like these lawyers said, I think that it would the courts would identify them as a business entity that they are most similar to, whether that be a general partnership or some other type of business entity under California's statutory framework that this DAO would most likely resemble. But all that said, it's just, as I've said before, a DAO is just a fancy way of looking at, a decentralized, there's that word decentralized. It's just a fancy way of looking at a different type of business entity, right? Whether, you have any understanding of how LLCs work or partnerships, it's just an entity that functions like a business, but with a different structure in terms of how the members are treated and who would actually be held liable in the event of any sort of negligence or misconduct under the law, right? But the thing is with DAOs is that these DAOs, they can't just operate independently without any sort of fiduciary that operates in the quote-unquote real world that handles day-to-day operations on behalf of the DAO. And take, for example, if a DAO has a treasury and they want to use some of those funds to convert them to fiat currency in order to purchase land or to purchase a replica of the Constitution, you're going to need either a lawyer or an accountant or some sort of fiduciary to actually physically go to the bank and to physically draft up the documents and to physically handle the actual exchange of the funds, right? The DAO itself can't just impart its consciousness into some sort of robot and then have that robot operate on behalf of the DAO under the DAO's programming. No, you need some sort of bridge into the real world. And I think that the more that these cases play out, it's going to be interesting to see how the courts interpret existing law, how legislatures will develop new law, and the interpolation of existing new frameworks and new fact patterns that arise that will ultimately determine who's liable, right? Who bears responsibility, and how DAOs are going to be treated in court. So, interesting case. I think that this is just going to be one of many. I think that there is going to be some sort of liability here on behalf of this DAO. I don't know if they're going to hold the individual named plaintiffs responsible, as we saw there were a few individuals that were named in this case, but I think that if there is a judgment rendered against this DAO, I'm interested in to see how the court will ultimately force the DAO to make good on that judgment and make the plaintiffs whole, and the actual mechanisms by which the court makes the DAO enforce this. I don't know, is there going to have to be a vote, a proposal, or, how is that going to work? Is the court going to demand that some sort of third-party court-appointed official actually gets access to the DAO's treasury? Are they going to freeze the DAO's funds? We don't know. These are all very novel issues, and this is what makes this aspect and these areas of the law really so fascinating and so interesting, at least to me. And I hope to you as well, which is why you're watching this channel. So with that said, I hope you guys enjoyed this content. Please, if you did, hit the like button, give us a thumbs up, and subscribe to our channel. We'd really appreciate that as we hope to grow and continue sharing this content with you. And so with all that said, thanks again for watching, and we'll see you all in the next video.